Hello, I'm Timothy Wiseman, and today we are going to discuss how long you have to file a civil appeal in Nevada. Very briefly, an appeal is a request for a higher court to review the decision of a lower court. An appeal is normally begun by filing a notice of appeal in the court from which you are appealing. However, the exact details of how you appeal, how long you have appeal, and which court you are appealing to vary depending on which court you are appealing from. There are several courts that concurrently have authority within Nevada. For instance, the federal district courts normally give you 30 days after the entry of the judgment or order you are appealing from to file your notice of appeal. However, there is a fair bit of nuance to that. For instance, certain governmental entities get 60 days rather than the normal 30 to file their notice of appeal. Certain motions can toll, which means to suspend the running of the time to file the notice of appeal. The federal district courts have the authority, under good cause, to extend the time to file the notice of appeal. In fact, under some circumstances, a federal district court can reopen or retroactively extend the time to appeal even after the normal window to appeal has already closed. If you are filing a cross appeal, you have either the time in which you had to originally file an appeal or 14 days after the notice of appeal, the original notice of appeal was filed, to file your notice of appeal. A cross appeal essentially is when one party has already filed an appeal and you want to also file an appeal in the same case. This can happen when both parties are unhappy with the order for different reasons. If you are appealing from a Nevada state district court, the appeal is always taken to the Nevada Supreme Court. The Nevada courts use what's sometimes called a pushdown model. In other words, all appeals from a Nevada district court are made to the Nevada Supreme Court, but the Nevada Supreme Court may then decide to refer some of the cases down to the Nevada Court of Appeals. If you are appealing from a decision of the Nevada State District Court, you generally have 30 days after the date that written notice of the entry of judgment or order you are appealing from is served. When you serve an order, that means to formally deliver it to the other side. Currently, it's normally done electronically, but there are other methods that can be used. Again, there's some nuance to this. First, unlike with the federal courts, the deadline to file a notice of appeal from a Nevada State District Court is jurisdictional. If a notice of appeal is filed late, the appeal must be dismissed. It cannot be heard or considered by the appellate courts. The timeline to file a notice of appeal from a Nevada State District Court normally cannot be extended. You must file your notice of appeal from a Nevada State District Court decision on time. However, much like with the federal district courts, there are certain motions that, if timely filed, will toll or suspend the running of the time to file the notice of appeal. And again, if you are filing a cross appeal, you may file that either within the original time period or within 14 days after the first notice of appeal was filed, whichever is later. The justice courts in Nevada give you even less time. You must file the notice of appeal within 20 days after service of written notice of entry of the judgment or order you are appealing from. And the small claims courts in Nevada give you even less time. You only have 5 days from the entry of judgment, and there is no notice, and there is no notice of entry of judgment. This is a very short timeline, and if you believe that a decision of a small claims court is in error, you must move quickly. Now, to make this even more complicated than it already is, there are differences in how the courts calculate time. The exact method for calculating time varies between the different courts in Nevada, and a full discussion of that topic is beyond the scope of this particular post. However, in general, with most courts, you will not count the date of the triggering event. In other words, if you are served a written notice of entry of judgment from a Nevada State District Court decision, you don't count that day on which you received service in calculating your deadline to file the notice of appeal. You begin on the next day. And if the final deadline would fall on a Saturday, Sunday, or other legally recognized holiday, the deadline will instead be considered to be on the next court day. Now, as you can tell, this can be an extremely important topic, especially for those courts where the deadline to file the notice of appeal is jurisdictional. And it can also be a somewhat more nuanced topic than it might at first appear to be. Therefore, if you have any questions, especially about a specific case, you should contact a qualified attorney. Thank you, and have a good day.